Welcome to the Probate Nation television show. We continue our discussion about how to probate an estate of a loved one. A Virginia probate is a process to transfer the title or ownership of probate assets to the beneficiary of a deceased person. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine, probate of an estate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets remaining are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probates seem to never end. Our program today introduces you to the Loudoun County Commissioner of Accounts, who oversees the probate of Loudoun County estates. The Commissioner has oversight of and must approve many of your decisions in probate, from what you propose to pay or have already paid, to what you distribute to each beneficiary of the Loudoun County estate being probated. This program will identify steps to take and pitfalls to avoid, so you receive the Commissioner's necessary approval to continue on your probate journey. With us today is the Commissioner of Accounts, appointed in December of 2013 by the Loudoun County Circuit Court to oversee all fiduciaries qualified in Loudoun County, including executors and administrators of estates, trustees of testamentary trust, guardians of minors, and conservators of incapacitated adults. Prior to that appointment, she served for 7 years as the Loudoun County Deputy Commissioner of Accounts. She also maintains a private law practice as an estate and trust attorney with the Leesburg law firm of Haynes and Dickerson. Please welcome Mindy Hetzel, Commissioner of Accounts for Loudoun County. Mindy, welcome, and thank you for taking the time to come and talk to us today. You know, we talk about the Virginia probate process, and it's really quite unique. You know, can you tell us a little bit about the history, about the creation of your office and the context of that probate process?
Sure. So prior to the 1850s, before there was a Commissioner of Accounts system, the fiduciary who would oversee the estate got to pick their own commissioner, and that would be the individual that would make sure they administered the estate properly. They often picked a friend or a neighbor, and as you can imagine, those individuals often didn't know much about the law generally, or trust in estates particularly, so there was quite a bit of litigation. So for the legislature to try to put an end to that, they put the purview of supervision of fiduciaries under the circuit court in approximately 1850. And the circuit court, to bring you up to date to the current statute, the circuit court is to appoint a discreet and competent attorney at law to be the Commissioner of Accounts. In each can be one or numerous commissioners in each county. Okay. So the unique thing about the Commissioner of Accounts system generally in the country, there are two kinds of probate systems. There's the the probate court system and the commissioner system. So the court system obviously is just another court like the circuit court, the district court, so that individuals, to get anything done, actually have to go to court and go through some sort of procedure, file some kind of pleadings. Our system is much more informal. I am an attorney, obviously appointed. I have my own law firm, and so it's a very laid-back atmosphere. We invite people to come in, ask questions, get help. So we try to make it as informal and as unintimidating as possible.
Now, can you tell me a little bit about the volume of cases that you see in your office as Commissioner of Accounts? So
last year we had right about 900 cases. So, and that's spread between estates, conservatorships, guardianships, and foreclosures. Okay,
very good. Now, when people first get qualified, what initial information or materials are being offered to the personal representative to help kind of guide them on their way?
So when they qualify before the circuit court, particularly at the probate office. And so at the probate office, they will give each fiduciary a packet of instructions. It's a fairly thick packet of instructions that the probate office and my office put together. Together with those instructions, they give you a set of timelines to remember, which hopefully, so you don't have to search through the instructions and figure out what your next step is. Sure. So a list of timeline, and then specifically a sample of the documents you're going to have to file so that you know exactly what you're expected to file.
Okay. Now, on the screen, we're going to show our viewers, this is a cover page of the instructions and duties of an executor, which is one of those pieces of information that's given out to you. And this is quite a lengthy document. It goes on for some 28, 30 pages with a lot of detail. So
Yes.
if you can follow that, you'll be one of a few probably.
That's absolutely right.
But after someone actually qualifies to probate an estate, what's some of the very first things they ought to do to get their estate going?
Well, speaking of the instructions, they should absolutely read the instructions. I think not only the detail in the instructions, but getting an overview of what the estate process is, the probate process, is very helpful. We recommend, if they have any questions after they read the instructions, to give us a call. We want everybody to start off on the right foot, and so reduce the number of errors that are made at the very beginning.
Sure. Now, one of the critically important roles of the Commissioner of Account is to oversee and audit and approve the inventory and the accounting that each one has to make, each fiduciary has to make. Can you explain that process with those filings and how you guys take care of reviewing those?
Sure. So each fiduciary has to file an annual accounting with my office. It's literally a document that begins with, first they file an inventory. Let me go back to that, which is a list of the assets that the individual had on their date of death. So the first account, for example, goes from the date of death through the end of the first accounting period, which is usually 12 months. And so that accounting will reflect everything that's happened with those assets during the 12 months. That means every receipt, every disbursement, a gain and losses on stock, every distribution is itemized on that document, and they provide supporting documents with that accounting so we can make sure that they have administered the estate in accordance with the will and the law.
Right. So when they start with the inventory, they don't really need to support what they put on there as far as values, but when they get to the accounting, they do have to support the remaining assets on hand.
Correct.
Once they get to the end of that first period.
Correct. The inventory is under oath. There's a statement under oath. And then it's pretty, once we get to the accounting and they have to provide the supporting documents, it's pretty obvious if there was an error on the inventory, and then we go back and do an adjustment to correct that.
Okay, good. Based on your many years of experience, auditing and reviewing accountings and handling estates at the Commissioner, do you have any particular tips for people as far as filing an estate account?
Well, again, I go back to reading the instructions, getting a very good idea of the process to begin with. What the majority of the accounts that we have a problem with have mostly to do with not sending all the proper supplemental information. So just make sure you really can detail each entry on your account. Like for disbursements, you should have a canceled check and you should have a receipt showing to whom the disbursement went. So if you have enough information, we're pretty close to being, the majority of the accounts are kicked back for that. Some because the account doesn't balance, but that's a small number. It's usually for not enough information.
So related to doing the accounting, I guess one of the very first things I know that's in your instruction is to make sure that when you open up an estate checking account that it's just for the estate, and that they will produce for you copies of the paid check so that we can actually support those on the accounting. Is that one of the things you suggest?
Yes, absolutely. Okay. And the other thing that I would tell fiduciaries when they first qualify, two important things that I should have mentioned earlier. One is that they should open a estate account immediately and close all the decedent's accounts. Oftentimes, automatic debits will keep coming out of there. On one case, we had a fiduciary whose son kept using a debit card and drained the estate account. The other issue is tangible personal property. We have a lot of, unfortunately, siblings or beneficiaries that tend to help themselves to the tangible personal property. So we recommend that you try to physically get control of that property. If you have the house and you're selling it as a part of the estate, change the locks. If not, actually physically get the tangible personal property and put it in a storage facility so that you can protect the assets.
Okay, good. That's a very good suggestion. So I guess one of the common reasons that an account is not approved by your office is because the numbers just don't balance correctly. You've got either
the numbers don't balance, or they just don't have all the information we need to approve it. I would say the majority of the accounts are approvable. Not that people are doing anything improper, it's just we don't have enough documentation to approve them.
Do you run into any special problems with accounting for beneficiaries that are overseas, trying to get documentation to support?
Yeah, well, we run into people who are in the military, so there's not a lot of communication. We run into people in countries that not only don't speak the same language, don't have the same alphabet. So we have a lot of, oftentimes they send whatever their equivalent of a certificate or affidavit is, and then we have it translated in the States. So we it's a process. We try to be as flexible as possible, but we have to have enough information to be confident that the beneficiary has received the assets.
Of course. Well, obviously one of the the ultimate beneficiaries of the estate is the beneficiaries, who are either by intestacy or by will. So what type of tips or advice do you have for beneficiaries as how that they should be, what they should be doing in the context of a probate?
So I will tell you that the majority of beneficiaries that I end up hearing from are upset because they want to know why the estate has not been distributed, why they have not received their funds. And I think that a lot of that stems from not understanding the process. So I suggest, not that they're going to read all the instructions, but at least look at the timelines and understand that really they shouldn't even file a first account before 6 months. And then the first account, if in the normal course of business, isn't due until a year. That I also tell them that we recommend that the fiduciary wait enough time so they know what all the assets are and all the debts are. You don't want to distribute something then realize, oh, we've got another debt that came in and we have to try to get the money back. So I recommend they be patient. You know, they can certainly call our office. We talk to beneficiaries all the time and let them know what the status is. So I think just understanding the process and being as patient as possible, which is often hard.
And do you encourage your fiduciaries to communicate to the beneficiaries, let them know what's going on, send them copies of the inventory or the accounting so they're familiar with what's happening?
So I think best practices is always to provide information and communicate with them.
Okay.
A lot of times there are, the relationships aren't that great. So at the very least, I think you should send the documents, even if you're not communicating with them. But you are required, there's a statute that a beneficiary can request in writing that they provide the documents that are filed with my office, and they actually by law are required to do that. And we follow up and make sure they've done that.
But usually the best practice is just to go ahead and send them anyway.
You will avoid many problems if you just communicate with them.
Sure.
Absolutely.
Sure. I know you mentioned about people fighting over tangible personal property. Now, I know we're going to get into some of the other issues that your office takes on, but do you folks get involved in helping try to mediate those types of back and forth that can go over an asset that has very little value?
Yeah, so I will say that a lot of the biggest issues are over the smallest things. We literally had someone who wanted the other half of a dining room table. And so I will tell you that the majority of the time I try to get involved because there's no reason that that should go up on a delinquent procedure because they can't distribute the assets. There's not enough money normally to support that kind of a proceeding. So I often invite everyone into the office and try to, outside a hearing procedure, just to try to figure out, listen to the person, the beneficiary who wants the asset, and just try to explain what the situation is. I often experience that if they feel like they've been heard and I can explain to them why or why not I would or wouldn't approve this distribution, what issue I have with it, they're a little bit more understanding versus coming from a sister or a brother or somebody that they have an emotional relationship.
I think that's a great practice.
Yeah.
That's a great practice. Well, before we can get to the beneficiaries, one of the things that comes up, we have to deal with creditors. Okay, so is there a process to figure out who the creditors are? And can you tell us a little bit about that process?
Right. So if there's an estate where you're not that familiar with the decedent and you've got boxes and boxes of statements, you can't figure out what the assets are, there's a procedure called a debts and demands hearing where you can request that I hold a debts and demands hearing. I then advertise it in the paper and ask that all creditors come forward at a certain time to assert their claims. In addition to that, creditors, and there are plenty of savvy creditors, whether it be credit card companies or hospitals, who have already filed claims with my office. So on the day of the hearing, I first determine whether or not any of those claims are contested, so whether the fiduciary believes that they're proper or improper. If they think they're proper, then I just go ahead and acknowledge, I do a report acknowledging that everyone is proper and payable. If not, I then hear evidence. The creditor will tell me why they think the claim is owed. The state will then tell me why they don't think it's owed, and then I will determine if it's proper and then ask the estate to pay it or not to pay it.
Okay. Okay. Now, in that vein, though, one of the most difficult things that can arise in an estate if it turns out that the estate has more debts than it has in the way of assets. And that's a landmine for so many problems for a fiduciary. Tell us how your office can help those fiduciaries navigate those landmines.
So if anybody has an insolvent estate or thinks they're going to have an insolvent estate, which unfortunately is happening more and more with housing prices. Houses are underwater. They don't know it. They're paying the mortgage before they know it. They've got more debts than assets. So if you think you're going to be in that situation, or even if you're not familiar with the assets and you think you're close, we recommend that you contact an attorney. I think the best advice is to talk to someone who can represent you personally. If there aren't enough assets, or if for whatever reason you don't want to contact an attorney, we ask that you call our office. At least we can give you the statute and kind of go through the list of priorities, because that's once an estate's insolvent, you have to adhere to a code section, and you have to pay each debt based on a list of priorities. If you don't pay them on the list of priorities, then you can be personally liable. We've had more than a handful of fiduciaries have to pay their own money in because they paid debts that were not properly payable under that statute. So talk to an attorney and then come into our office. And we often, prior to making the final distributions, we invite someone to go ahead and file a draft accounting with laying out all the disbursements pursuant to that statute, and then we can say it looks good or this is something that needs to be changed, so that they don't make the distributions and then we find out that there's a problem.
And this is one area where a lot of times the funeral comes up, someone pays for the funeral, and then they want to be reimbursed, and we have an insolvent estate, and the statute actually limits how much they can be reimbursed. It really is sad sometimes that people are out of pocket a lot of money, and they can't really be reimbursed.
That's right. A lot of people can't be reimbursed. Yeah, I mean, the administrative expenses are first, but funerals down, and it's $3,500, I believe now. The statute recently changed, and people are paying upwards of $10,000 for funerals.
Very much so.
So I don't see any for $3,500. Yeah, and so what'll happen is if they pay $10,000 and let's say the allowance is $3,500, they get their $3,500, which is if you get to that category, and then the remainder of the claim goes into priority 9, which is general creditors. So then they'll get a percentage of their claim back based on what's left at the end of the estate for priority 9 creditors.
Sure.
But yes, it's a difficult process.
And so the executor does need to be very careful about this automatically reimbursing that bill.
Or paying the mortgage, or you really should not pay anything. And I find that creditors are pretty understanding if you tell them that it's insolvent up front. I literally would not pay anything except for administrative costs, because those are the only things that are Class 1 and guaranteed to be proper.
To be proper under the statute, of course. How about some other advice you have for the fiduciaries you see in your office? Things that you suggest that they be wary of from the very beginning, or things that that people seem to trip over all the time.
Well, the biggest issue, I think, we have kind of two kinds of fiduciaries. Ones that are overly maybe nervous and overly, they want to do everything just right, and those that don't take it seriously at all. There's a happy medium in there. So we really try, the most important thing is stay in contact with our office. I mean, I think what I tell people is, if you're having a problem, if you think you've done something improper, if you have a question, just contact us and we can help you. We don't like to send late letters. We don't like delinquency processes. Our goal is to get everything approved, but it happens. People get behind, particularly in this area of the law, because you've got a lot of people who they just had a death of a loved one, so they're emotionally fragile, and then people have problems. They have health problems. I find that most people don't do it maliciously. They just don't because something happens and they're not able to. So what I tell, one of the major things is, just give us a call. We will help you work through it. Short of stealing the money, we can always figure something out. And we try to be very flexible on timing. So if you're running behind, as long as you call us and tell us, we're usually happy to grant the extension to try to, give you enough time to figure out whatever personal issue there is that's keeping you from filing.
We forgot to mention at the beginning, though. Tell us a little bit about how you're staffed to take care of all this, because there's a lot of things going on in your office.
Yes. So there's only 3 of us. Our county is about 350,000. Wow. So, yeah. So I have an administrative assistant, and I have a head auditor, and then myself. So my administrative assistant, of course, takes care of the phones and the letters, correspondence. We have a special system that keeps track of all of our files. So she runs that, which is a very important part of the office, because everything's run on timelines, as you know. In addition to that, Kristen, that's Nancy, my head auditor, she really pretty much puts her hands on everything. She sees everything except for probably the more complex ones. If there's a legal issue up front, or we've got a delinquency that looks like there are going to be issues, she will hand those right to me. But otherwise, she audits, and then she'll prepare need letters, late letters, and then that comes up to me. My job is to obviously oversee both Nancy and Kristen, and then I I, of course, hold all the hearings that we have in our office. I also deal with the legal issues, and oftentimes I actually audit accountings. This time of year, all the trust accounts are due May 1st, so we're just inundated. So that's a unique time of year. So I'm definitely in the trenches with them trying to get the accountings done.
So that's very, very helpful to know that if there is a problem, that you are really, really hands-on in the sense that you will step in and try to head things off at the pass before the problem becomes really serious.
Yeah, unfortunately, sometimes people are a little bit more receptive when the commissioner calls versus than the assistant.
That's interesting.
Calling, yeah, I find that. Yeah, and again, and there's some decisions that I can make off the bat that Kristen wouldn't feel comfortable making. So I find and I try, if you can't my first line of defense is Kristen. You call and she can answer 99% of the questions. But if you want to talk to me, you certainly can. Maybe not that day, but I usually call everybody back within 24 hours. So we have an annual, I have a monthly forum where anybody in the public can come one evening a week. But it's helpful, but I wouldn't say it's necessary because, again, we do try to meet people's needs, throughout the month. And if they have an issue, they can certainly come to me or Kristen.
That's awesome. It sounds like you guys just do an amazing amount of work, but there's a lot of work still to be done. So does someone need to hire an attorney or an accountant to get through all this process?
So if you have an insolvent estate or you are the guardian of a minor, I would say absolutely consult an attorney. Whether you want to hire them after that is up to you. I think it's probably a very good idea. I will say the one pitfall I find with people hiring professionals, the code says that the fiduciary can hire a professional if it's reasonably necessary for the estate's interests, and it has to be for a reasonable fee. So, of course, insolvent estate, guardianship, somebody files suit, there's a lot of reasons you could use a professional. So just make sure you don't hire a CPA and you find him balancing your checkbook. And you don't hire an attorney and he ends up writing the checks. Because those things the fiduciary has to do. You can't pay somebody $250 to $300 an hour to do the administrative work.
Sure.
But there are a lot of very legitimate reasons, and we encourage and really appreciate when attorneys and CPAs are involved. The one other thing I do say to a lot of fiduciaries when they're looking for an attorney or CPA, probate's a very niche area of the law. So somebody who does a lot of tax work may not be familiar with probate accountings. An attorney who does trust and estates may not be familiar with probate accountings. So I think it's really important that you know that this individual does this kind of work. Makes it much easier and makes the process much shorter.
Of course. Well, we've covered a lot of material in a very short period of time, and thank you for doing that. Is there any final thoughts you want to share with our viewers and the folks in Loudoun County about the process by which your office interacts and helps them probate an estate?
I think I would just reiterate what I said earlier, which is we tried to be as client-friendly as possible. If you want to come the first day, you qualify to get some advice. If you have any questions, call us. We really try as best as possible to keep everybody on track, and we go out of our way to meet the needs, whether it's just meeting with somebody or actually helping them get the papers together to file the account. And we do as much as we can to try to keep people off the delinquency registers for ours. We remove very few people, and that's because I spend a lot of my time calling these people prior to court, asking that, please come. I mean, we've had individuals who are older, and we're like calling their assistant to see if the assistant can pick up the accounting and bring it in. So there's not a lot we won't do. I find that taking those kind of people to court, older people or people who just can't emotionally or having issues, it's not productive. And it's not going to help me, and it's only going to hurt that person. So we really do try to bend over backwards. So if I can say our office is very open. Don't let the process intimidate you. I think a lot of people feel intimidated by the process. Don't let the process intimidate you. Do your best, and we're going to work it out somehow.
Awesome. Well, Mindy, I want to thank you for taking the time to come and talk to us today, also for visiting with us, and also for your service to the Loudoun County Circuit Court and to the citizens of Loudoun County. Thank you so much for doing this.
My pleasure. Thank you for having me. I hope it's helpful.
It will be very helpful, I know. I want to remind our viewers that the Loudoun County Commissioner of Accounts and the Loudoun County Probate Office have collaborated in the preparation of a very useful and detailed booklet that was mentioned earlier in our program called The Instructions and Duties of an Executor or Administrator for the Decedent's Estate, where it provides answers to common probate questions that arise from probate, which you can find on the Loudoun County Probate Office website. The booklet will also be posted on the Probate Nation website as well. We encourage anyone who wants more information to take a look at that helpful instruction booklet. Without a doubt, probate can be complicated and confusing. Commissioner Mindy Hetzel and the entire staff of the Loudoun County Commissioner of Accounts Office do a wonderful job of explaining, teaching, and guiding those responsible for probating Loudoun County estates as to what needs to be done, when, and by who. From inventory filings to accountings, from debt hearings to distributions to beneficiaries, each and every topic and much more is laid out in simple, plain language in that very informative instruction book that they prepared. If you have questions, though, give them a call or shoot them an email, and the staff will do their best to guide you. But if you prefer face-to-face communication, schedule a time to visit them at their office in Leesburg near the Loudoun County Courthouse. What I take away from our visit with Loudoun County Commissioner of Accounts Mindy Hetzel today is that if problems arise in an estate probate, as they will from time to time, do not hesitate to lean on them for assistance. If they see problems with an accounting, Mindy herself will get directly involved to sort it out and get you back on track. In short, Mindy Hetzel and her entire staff are easy to work with and very proactive in mentoring executors and bringing folks together to resolve differences so the probate is administered properly and closed promptly. They perform a great service for the Loudoun County community, and we are thankful for their commitment in doing so. This brings us to the conclusion of our show on the Loudoun County Commissioner of Accounts. You got qualified in the Loudoun County Probate Office, and you now understand the role of the Commissioner of Accounts in your Loudoun County probate journey, including what you need to file with them and how they can help you along the way. Future shows will delve into the details of the state administration. But in the meantime, take a moment to enjoy the view as your probate train picks up speed and continues on its journey through the Loudoun County countryside. On behalf of myself and the Probate Nation, thank you for visiting with us.